In terms of the EEOC, oftentimes you'll receive what's called an intent to mediate form. And this is typically sent to the respondent, who is usually the employer in these cases, asking whether they have any desire to mediate the claim. Of course, you should always seek legal advice when the EEOC is in contact with you in order to determine whether your response to that type of inquiry is appropriate for your particular company. There are benefits, pros, and there are cons to mediating, and there are certainly measures that can be taken to protect your rights in terms of paying any kind of a settlement that it may be considered to be too much for the particular facts of the case or the particular claim that's against you. One of the things that always needs to be evaluated in deciding whether to go to the EEOC for mediation is whether you have any defenses to the claim, whether those defenses are viable, or whether even at the end of the day, even if those defenses are viable, you might be facing several years of litigation, which of course in and of itself is costly and expensive for you as an employer. So typically, when you receive an intent to mediate form, you need to evaluate the case with an attorney who has experience in the area of employment law so that you can get the best advice and the best information that you need in terms of determining what your risks are going forward should you not resolve that claim quickly. Of course, going to mediation doesn't guarantee that there will be a settlement. Mediation is a process, and oftentimes it does take several rounds of negotiation in order to come to a settlement. And there's no guarantee that the claimant in a particular case is going to be willing to accept whatever it is that the employer is offering. However, with the assistance of counsel, you can always try to be as persuasive as possible in this type of proceeding and at least give the complainant a little bit of information on what it is you intend to do if the case were to go to litigation, full litigation, court hearing, depositions, that kind of thing, in order to defend the claim. And sometimes that can help the claimant become more reasonable, certainly in any kind of negotiation.